Any mention?
Please, Your Lordship. My Lord, I beg to make a mention of item number 123 to 157 and 159 as the conducting counsel is in this.
1 second, sorry. 1, 2?
Item number 123 to 157, and including item 159.
123 to
157.
157
and 159.
Why?
My Lord, the conducting counsel is indisposed, Your Lordship.
What happened to conducting counsel?
He's not keeping well. He's recovering from ailment, Your Lordship.
No objection.
When do you want this?
2 weeks, my Lord.
It's okay. 2 weeks.
For hearing?
For hearing, Your Lordship.
Yes.
For item 158, Your Lordship.
One item do you have?
Connected matters, Your Lord.
Connected matters.
Yeah. Okay, this item 1, 2, 3 to 157.
1, 2, 3 to
It'll be 1 to 159 only.
159,
Yes. 1 to 159. Stand adjourned to 2 weeks due to the illness of the arguing counsel. Yes.
Obliged, Your Lordship.
Your Lordship, I beg to mention for pending writ petition number 321 and Miss Case 204 for urgent listing.
What is the matter about?
This is about that Meghalaya Cricket Association. So their urgent is that now we have to prepare for the domestic tournament.
Who are you?
I'm the petitioner in the 321. Petitioner.
You're the president of the MCA?
No, I'm the General Secretary.
Suspended secretary.
But just it's been suspended?
Yes.
So how is he functioning? What is he doing now? He's suspended. Can he discharge his functions?
That
Who's in charge now?
is now there's nobody.
President.
Then has suspension been revoked?
That
Who's the
the
secretary?
Rienol.
No, whatever. Who's the secretary is secretary is a allegation against him. In the other petition, I remember he was
Yes,
there's a suspension or something there.
He has been suspended.
He was suspended.
This is a pending matter prior to the suspension.
No, whatever it is, because I think if I remember correctly, some apex council suspended and this and that.
Yes, madam.
That is just a suspension for the apex council. Before we file the.
Are you under suspension now, or you?
Yes.
Continuing? Under suspension.
Lordship, my Lordship.
Then
General Secretary has been suspended, Lordship. His suspension is under challenge, Lordship. It's in item number 3 supplementary list today.
okay.
Yeah.
Then we'll hear it. Where Monday?
Tuesday.
Tuesday, not Tuesday. I had taken either on Monday or Wednesday.
Wednesday.
Yes.
Hello, Blind.
Supplementary list item number 1.
I've already served copies.
Yes, caveat
Caveat we will start.
2026. Senior caveat petition. Mr. Jero and a senior counsel with so-and-so is present behalf of a caveator who has been arraigned as respondent number.
No, the caveator is read as respondent number 4 and 5, madam.
Respondent 4 and 5 in the writ petition. Caveat stands discharged. Yes.
May it please your lordship. My lord, against an expression of interest dated 2/12/2023.
The same matter that NOC.
My lord.
What happened now?
Now, my lord, what has happened here is after the NOC was issued to me by the headman,
you withdrew the case.
My lord, I subsequently withdrew the case with liberty to file a fresh one. Now, my lord, what happened here is the EOI invited offers from landowners for setting up a roadside oil fed depot on a 30 years long-term lease. My lord, I offered my land. My land was found suitable, and after my land was found suitable and was shortlisted from amongst 14 competing bidders, the respondent NRL conveyed the approval of the competent authority that my land has been selected. Now, my lord, prior to selecting my land, the NRL undertook due diligence They verified the status of the
I
land.
remember that case you would wrote
My lord.
the other day. Yes.
Now, my lord, what happened was that thereafter, my lord, after the NOC was issued by the
NOC and
the NOC was issued by the headman, the only formality left was to execute the lease. My lord, for that NOC was required from the Deputy Commissioner's office. My lord, I submitted all the papers. The Deputy Commissioner kept my application in cold storage, against which I came before this court by filing a writ petition. Now, my lord, after I filed the writ petition, a copy of which was served to the respondent NRL also, the NRL issued the impugn letter. The impugn letter, my lord, will find at Annexure 15, page 141.
Lecture?
Annexure 15, page 141 of the writ petition, my lord. Now, well, by the impugn letter, the respondents have cancelled my offer.
Okay.
Cancel my offer, citing very vague reasons.
Been signed prior to the any agreements been signed which binds them in any manner.
My lord, for that I'll have to take my lord to the EOI, my lord.
So now, okay, fine, they've cancelled on 11/6, right?
My lord, 11/6 after I filed after they received notice of my writ petition. Now, my lord, the reason cited in this cancellation order is very vague. And moreover, my lord, this cancellation order was issued without even affording me a chance to show cause on this, my lord. They have issued the cancellation order saying that I do not have clear title over the land, whereas earlier they had carried out due diligence and they found out that my land was suitable. I had clear title, free from encumbrances, etc. To that effect, they filed an affidavit in the earlier round of the litigation as well.
Yes.
So, my lord, agree by this, I am before my lords. My case is that, my lord, though it is a EOI,
How binding
subsequent developments have.
EOI.
I'll take my lord to EOI. The EOI is at is Annexure 3. Annexure 3, page 26 to 36 of the writ petition.
Does it say anywhere once accepted that you know what the process?
My lord, it's
No.
One second.
My lord, page 32, my lord.
To page 79.
One second, Mr. Roy. You'll have your chance. Yes.
My lord, will kindly come to page 32.
Yes.
My lord, it says, page 32, point number 7, selection procedure. The NRL shall inspect the land of the bidders participating in the EOI to shortlist the plots that fulfill the requirements of the NRL as mentioned in the above clauses. Selected shortlisted bidders will be issued tender paper.
No.
For
See, what
submission-
about this clause 4?
My lord,
Clause 4 of this selection procedure.
my lord, it
NRL
says that
reserves the right to accept
it reserves the
any
right.
or all applications or to annul this process at any time without signing.
My lord,
at any time.
my lord,
without any reason.
my contention is that cannot be done at this stage. Once
Okay,
they
yes,
have,
Mr. Roy.
once
what
they
has
have
happened?
accepted, they have conveyed the approval. And
Yes.
also, my lord, I'll just, if my lord will, please allow me to take my lord to Annexure 9.
Yes.
My lord, Annexure 9 is the letter written by the respondent number 5 to the Deputy Commissioner asking for permission for transfer of the land. My lord, Annexure 9 is at page 43.
Yes.
Page 43.
Yes.
Now, my lord, it says that for smooth and reliable supply of petroleum products, as such, NRL has proposed to establish a road-fed depot in the state of Meghalaya. Accordingly, a EOI was issued by the NRL in so and so, detailing the land requirements and the criteria for selecting the land for construction and operating of a product storage and dispatch terminal. After scrutiny of suitability of offered parcel of land, the land given below was selected by the NRL management on H1 basis on lease for 30 years. Details of the land selected, my lord, my name is there. Then my lord will kindly come to the next page. Along with this letter, certain documents were enclosed. My lord, the first document is the particulars of the lease in format A. Now, my lord, the lease, my lord will find is at page 45. My lord, though it's a draft lease, but my lord will kindly see it is duly signed. It bears the signature and seal of the respondent number 5.
But does it bear your signature?
My lord, it does, my lord.
No, see page 49.
My lord, in the first page 45, page 45, 47.
Yes, Mr. Roy.
My lord, first of all, my lord, we have, and in fact, my lord, we are with the petitioner for putting up a storage plant there, but expression of interest was issued on 3/12/2023. Now it's almost 2.5 years. There is no, and then there is a litigation coming up. In fact, if your lordship see the notice, imputed notice, third paragraph, lordship may see for a moment, my lord. On page 141, third paragraph.
Third paragraph.
Third paragraph. NRN has subsequent has above received a legal notice dated 25/10/25 from Srimati Distina Mal Bakri regarding ownership and objection of the use of the proposed emergency Essex exit road, including the plot of land. Notice claims rights over the said access road, which is necessary for development, operation, and statutory safety. Now, these all litigation, all that has put us in a difficult position, my lord. So that's why we have cancelled, and this notice was issued to them. Neither they have said that they have received the notice, neither
You're not represented against notice,
my lord.
You're not represented against this notice.
No, my lord.
Why?
My lord, we have challenged this notice, my lord, because this.
The thing is that fine. I think they've given you.
My lord, they have cancelled it now, my lord.
They've given a copy of that legal whatever.
No, my lord. Nothing is given to us, my lord.
Notice claims rights and
nothing is given to us, my lord.
Explanation in this petition also, my lord. There is no explanation in the petition also. So, my lord, doesn't want to go for litigation. The matter should be.
That's understandable.
We have cancelled the.
My lord, will kindly consider at what stage this was cancelled, my lord. This notice is dated.
You can't enforce a suit for special performance now by a writ petition. You have other remedy.
My lord.
Now, if you want special performance from the state, you can't compel them. Where, the thing is that you have not signed a lease also. Only this EOI.
My lord, it is a EOI, but
in notice, and then who's appealing for the state?
Lordship.
I'm appealing, my lord. I'm there, my lord.
Yes, you have anything to say? Nothing.
No, my lord, nothing further to add what my friend has already submitted. My lord, lordship has seen this matter earlier also, my lord.
Yes, you take a call.
My lord, my case here is that, my lord, it has now become.
See, the thing is that what kind of orders you expect?
My lord, firstly, my lord,
on what premise?
This notice is in clear defiance of natural justice, my lord. My lord, number one, the NRL is a company which is backed by
the thing is that you represent. Cancellation of
my lord, they have cancelled it without even, and my lord, on what grounds they have cancelled? They have said that we have received a legal notice, my lord. That is a very vague ground to cancel, my lord. When they have earlier conducted due diligence, it is their own finding that my land is free from all encumbrances. They say that this land has run into litigation.
You cannot ignore. Court will not argue with you. My lord. You cannot ignore what has transpired after that. If the letter of interest was given as far back as in December 2023,
my lord.
Now it's 26. That's because it's an essential commodity. Then you take a notice if you want. As what Mr. K.C. Gautam, the consul petitioner, issue notice. For number one, who's there? Number one, where's MS? Number one is Dr. Mozika is present. We have number one, and this corresponds 2 and 3. Advocate General along with Mr. ESD is present, and respondent 4 and 5 through Senior Counsel J. Roy upon behalf of the cavities 4 and 5. Stop. No further notice required. Yes, the grievance with petitioners with the impugned cancellation of their offer of land on lease for petroleum product storage. Where's this place?
My lord, this is at village Umran Dairy. Umran Dairy.
At Umran Dairy, Boy district. Have been submitted by Learned Counsel that the cancellation is absolutely arbitrary, as much as the entire process has already completed, apart from due diligence being conducted by the respondents 4 and 5. He therefore prays for appropriate orders. What orders you want? for appropriate orders. Yes. Next paragraph, on behalf of the state, was Mr. Giroy, who was made the initial submission, submits that the cancellation was occasioned due to the fact that though the letter of intent was issued as far back as on 3/12/2023, due to the events that transpired thereafter, which included prolonged litigation, the project being at stake, the respondents had thus cancelled the offer of land. Stop. From the state, nothing to say. Anyway.
Lordship note.
Yes.
Also, my lord, one more thing, my lord.
Yes.
The project has to be completed within
By
30/3/2027.
Yes, and further, it is submitted by the Senior Council that the project has a timeline for completion, which is
30/3/2027.
30/03/2027. Now, my lord, if the referee submits the no interference call with stage, this court has heard and counsel of the parties. It appears that the writ petitioner is himself or herself has not represented or made any objection to the cancellation before the respondent number 4 and 5. So therefore, looking at the that is represented against the impugned cancellation or taken any steps thereafter. Stop. In view of the circumstance of the case, new interim order was called for the stage, but appears at liberty to take recourse to other remedy if so advised. Yes. You file affidavit. Just about 2 weeks for affidavit. Yes. It's what they call it, essential commodity project. Is difficult.
My lord, if they claim that the project has to be completed by March 2027, my lord, they have to undergo the same exercise, my lord. How will they do it? And my lord,
it's up to them.
My lord, the reason assigned is very vague, my lord.
Yes.
Wait for what? Now,
Obliged, lordship.
Yes. What is this?
Very pleased, your lordship. There's 77 villages. For the already your lordship, the petition has came before this honorable court, and lordship directed them to participate in the public hearing for the Sri Cement Limited.
Oh, that
case.
Hot
So
topic, yes.
this time we have given with the land handling certificate, everything there, and DC also allowed us to participate. But what had happened? We are the landowner
of that area.
Of that area.
All
land handling certificate.
The project is going to be.
So what they did, the administration, your lordship will see, of course it's a very serious allegation. Your lordship can turn to page 10, your lordship will see, for the 31st hearing, public hearing, your lordship.
Page 10.
Page 10. In page 24, DC has allowed us that we have given the sought permission from DC, page 24, Annexure 5, your lordship. The petitioner and the other landowners, they were deputy council receipt and verbally at the bottom, your lordship. Deputy council receipt, lordship, and allowed verbally. They okay, you can participate with your land documents.
One second, where?
And
where he said
he received a copy.
Permission.
Received a copy here. You're also at the bottom, deputy council.
A copy doesn't mean that's it is something.
Yeah, we have asked for permission to be.
Where is he allowed to take part of public hearing?
No, allowed or verbally he allowed. Your lordship.
We can't.
I understand. So in fact, your lordship, what happened on the 31st, well, on page 10, your lordship can see the first paragraph. Your lordship, they occupy the surrounding and the place of the public hearing prior to that date, and they have to dug the road linked to the place of public hearing for about 3.5 meters wide and about 5 feet deep, which was at Lat Tongseng, which is about 2 kilometers before reaching the village Swenso at 11:30 p.m. of 37. Prior to public hearing, night time, JCB went and dug this.
No, that's another thing.
So
they go and file FIRs against this action of these whoever dug the road in your land. Then where's FIRs?
No, FIR copy I have not given, but this is the allegation that petitioner has. They have a video recording everything.
What's your prayer?
Prayer is only that they should not take us prayer at page 10 and 11 last
No
part.
compensation.
Only compensation. You take the land, no give the compensation.
We heard Mr.
Only that.
Hemanta, then the senior counsel, assisted by Mr. M. Lingdo, issue notice. Learned Advocate General with MSS Lalu is present on behalf of all the respondents.
No, Your Lordship.
On behalf of
1, 3, 4, 8 and 9.
1 second. On behalf of respondents 1,
3, 4,
4,
8 and 9.
8 and 9. There is no further notice on these said respondents. GHADC is appearing. Any standing counsel?
Yesterday I didn't,
No,
didn't
it's
get it.
notice to issue to the remaining respondents in 3 days. Just after 2 weeks for instructions are given.
In the meantime, I have a small prayer, Your Lordship, that
Yes, my lord.
no consent to establish or consent to operate to the here. That is interview.
The matter is already, it's already boiling another pot. You don't want to add another ingredient to it. Yes.
Anyway,
What's your
Your
right?
Lordship.
3,
Because only all he has to.
May it please. May it please, Your Lordship.
Yes.
My lord, I have taken the instruction, my lord. Your Lordship will have the instruction.
Which case?
This is the Yatra case. I'm sorry, my lord. Yatra. I'm sorry.
Lordship, this is-
number 3,
Item number 3 is, Lordship. Lordship, the petitioner is the Honorary Secretary of Meghalaya Cricket Association, Lordship.
You said just now he's been suspended.
He is under suspension, Lordship. He is challenging the suspension, Lordship,
Okay.
for the state petition, Lordship. The petition is before you, Lordship, aggrieved by the letter of suspension.
Where letter of suspension?
Lordship, letter of
Subject
suspension.
matter in the other petition, Mr. Pandey.
Lordship, no.
Yes, my lord.
He has been challenged for the first time. This, his Honorary Secretary's suspension is not under challenge, Lordship. This is the only writ petition, Lordship.
Okay. Where's the order?
That is page number 11, Lordship, Annexure 1.
Yes.
May I read, Lordship?
Yes.
June 27, 2026, Lordship. This is subject order of to so-and-so Honorary Secretary, Meghalaya Cricket Association.
Yes.
Subject order of suspension pending disciplinary proceedings, Honorary Secretary, Meghalaya Cricket Association, Lordship. I, so-and-so, President of Meghalaya Cricket Association.
Where's the operative part?
Lordship, the operative part would be para number 4, next page, Lordship. Page number 12. Accordingly, you, see so-and-so, are hereby suspended from the office of Honorary Secretary of the Meghalaya Cricket Association and from all associated responsibilities, functions, authorities and access to MCA resources, communications, accounts and records with immediate effect and until further orders. You shall not perform or purport to perform any act in the name of or on behalf of the MCA during period of the suspension, Lordship. Now, Lordship, the problem with this order is that he is not at all authorized by MCA Constitution, Lordship. He is the apex council who has the power to issue so cause or to take any disciplinary action, Lordship. The rule is very, very clear, Lordship. Lordship allows. I'll take Lordship to.
Yes. Where's the rule?
Lordship will kindly come to page number 38, Lordship, of the writ petition, Lordship. That's the MCA Constitution, Lordship.
38.
It starts from 37, Lordship. The para number 41, bottom.
Yeah.
Grievance redressal, Lordship.
Okay.
1. The types of disputes / differences that form the ombudsman ambit and the procedures for redressal are. A will not be relevant for our purpose, Lordship. I will take Lordship to B, Lordship, subpara B.
Yes.
Detriment caused by member or administrator. This is very clear, Lordship. If any member or any administrator or the association commits any act of discipline or misconduct or acts in any manner which may or likely to be detrimental to the interests of the association or the game of cricket or endanger the harmony or affect the reputation of interest of the association or refuses or neglects to comply with any of the provisions of the memorandum and / or the rules and regulations of the association and or the rules of the conduct framed by the association, the apex council, Lordship. The apex council, on receipt of any complaint, Lordship, shall issue a show cause notice calling for explanation, and on receipt of the same and / or in case of no cause or insufficient cause being shown, refer the same to the ombudsman, who shall pass an appropriate order after providing opportunity of hearing to the parties, Lordship. It's the apex council who can issue so-called, Lordship.
So the president
Doesn't have any power, Lordship.
Now you mean to say that there's no provision for suspension also?
There is provision for suspension.
Where is that?
Lordship, the suspension part is not clearly dealt with in the Constitution, Lordship. This is the only part where
you mean to say that the substitution orders were of jurisdiction? He should have issued
Lordship.
show cause first.
Lordship, he should have issued so called Lordship.
Okay. Then
Lordship, and Lordship, here the President has issued the suspension order in the guise of a recommendation from Meghalaya State Commission for Women, Lordship. That order, Lordship, will have at page number 42, Lordship.
42.
Lordship, the operating part, Lordship. And Lordship,
Very serious allegations. Under 23 women's cricket team. You're number 1 there.
Lordship. Yes, Lordship.
Yes.
If I may add, Lordship.
Now, does the president have any other power under the constitution to act independently?
President's
without-
no, Lordship.
He has no
President
power
has
at all.
President has invoked the emergency power, Lordship.
Then he has emergency powers, correct?
Emergency powers of
Where is
power, Lordship. Will have that at powers of the President, Lordship. Page number 25, Lordship. Lordship. 18. Powers and functions of office bearer, Lordship.
Yes.
A. President. The President shall preside over all the meetings of the association and shall exercise general supervision over the activities of the association. In an emergency, the President shall have the right to take all measures necessary to safeguard the interests of the association and to carry on its activities. The word used is emergency, Lordship. Though emergency, the word emergency has not been explained in the Constitution, Lordship, but ideally it would mean a situation where there is an impossibility of Apex Council to meet, Lordship. But here there is a vibrant and functioning Apex Council in place, Lordship. These matters should have been placed before the Apex Council, and Apex Council after deliberation should have issued a so-called notice, Lordship. That has not been done.
So you say that there's been a violation of the constitution?
Lordship.
The president does not have the inherent power to
Lordship.
suspend.
Lordship.
The suspension is not dealt with with regard to misconduct in the constitution.
Lordship. There is
Yeah,
no
so
mention.
the appeal for the respondents.
Lordship, I have instructions to appear for the President of MCA. Lordship, I'm praying if this matter may be taken up with other matters on Wednesday, Lordship.
I pray that notice may go, Lordship.
Yeah, notice has to go. Taken Wednesday. Yes. The other matter, but are you certain that the suspensions are subject matter there as a Pandey?
Lordship, I'm sure.
Yeah,
Suspension has not been dealt in any other matter, Lordship. Lordship.
Proceedings.
Lordship.
Before that.
Suspension has not been dealt with.
No,
in
I mean like there's no duplication proceedings. We don't
no,
know.
Lordship. Absolutely, Lordship.
Heard Mr. S. Pandey, counsel for the petitioner. You should notice MS Embrichiang for 1 and
For one,
Lordship.
Lordship.
for 1
Status for two,
for
Lordship.
1. Yeah. Yes, sir. For
The
1.
state is a formal party, my lord.
Yes, sir. As present, accept on behalf of respondent number 1. Then Attorney General with MS Sadu, present behalf number 2. No further notice on these respondents. Notice issued to the
Yes, that's number 3, Lordship.
number 3 within 3 years. As is submitted by the parties appearing that connected matters are listed on
Wednesday, Lordship.
Wednesday. That is the 12th.
12.
This matter together.
Lordship, I crave the sanction of the leave court, Lordship, to produce one document, Lordship. I'll file by
Why
every
not
affidavit,
next
Lordship.
in petition?
Lordship,
document?
this was obtained subsequent to filing of
What
the
does it
petition,
say?
Lordship. This is the reference made by the President to the Ombudsman, Lordship. After suspension, he has made the reference to the Ombudsman,
But that'll be
Lordship.
a different cause of action.
Lordship. Okay, Lordship, I'll just we'll hear it, Lordship.
Yes.
Deeply obliged, Lordship.
Yes.
4.
Yes, Mr. RP General.
I have taken the instruction, my lord. My friend will place the instruction, and the DC will provide the security, my lord. And kindly have the instruction, my lord.
Yes. Can you hurry up, Mr. Abraham?
Lordship has the
I'm on the one copy I'll give you.
it says, my lord, in paragraph. There is no problem in providing adequate security. Plus, my lord, it also says, my lord, that letter has been issued BDO Mansiram block shared a copy of letter of 6th August received from headman of Mansiram village, wherein it was stated that villagers had adopted a unanimous decision on 9th August to warmly welcome all tourists irrespective of any race, religion, etc. and who are visiting the cave, but will not allow any citizen or group to conduct any religious activities inside the cave. Although villagers do not agree to Yatra, but they would continue to treat all visitors on equal footing as tourists with respect and dignity. Yes. After detailed deliberation, it was decided to that.
Yes.
My lord, so there is a spirit of cooperation extended by the state where they are willing to hold the yatra on 9th. If lordship kindly looks at the this document, my lord, at point number 2, compliance with the 2025 SOP.
Yes.
Now, if lordship kindly goes back to the 2025 SOP, on the last occasion also we had submitted, we are completely open or agreeable to abide by that. Just one small issue may be outstanding, that is item number 9 in the 2025 SOP, reflected in 10th July 2025 letter. 10th July 2025 letter.
SOP, yes, SOP. Can you give a copy of the SOP?
My lord, I have just one copy.
One copy?
My lord will take it.
That you could refer was in the report. Huh? Was it not? Was it annexed to any affidavit or something?
No, it was just handed over last year.
Last year it was not annexed any affidavit.
No, my lord. It was.
No, it was very much there. Mr. Abraham, he produced it. Where is that SOP? Even you don't have copy anymore.
I have. We are just following the 2024.
No, where's SOP? I want a copy of that.
27th June 2024, my lord, soft copy. I have a
no,
soft copy.
You don't have a copy anymore also.
Give it to.
My lord can use my copy, my lord.
At least you should have copies. You produced it last year. Correct?
Yes, your lordship.
Then threw it away.
Yes, my lord. This is dated 27th June 2024, my lord.
That's 2024. This, the 27, that this, I have, sir.
That you say you don't have?
This 24th, your lordship. My lord, this is a previous SOP, my lord. This,
okay,
this is not in.
You take it back. Yes.
My lord, the SOP I have just handed over, my lord. Comment.
Yes.
It's dated 10th July last year. Lordship, kindly look at number 9, my lord.
Yes.
NOC from the local Darbar.
No, but that's settled in this.
So last year, my lord, last year what had happened was that very fairly Mr. T.T. Dinto appearing for the Darbar had considered that they have no objections in open court. So that number 9 became OTOs, my lord. But if 2025 is to be reimposed on us, that number 9 has to be specifically excluded, my lord. That's one, my lord. And number 2, my lord, the
thing is that
pouring of water, my
lord. The thing is that Mr.
Because it doesn't amount to a religious activity. So we are in complete agreement with the Darbar. We will not conduct religious activity. But sprinkling, my lord, is offering an insult to the deity.
How do you sprinkle? You just put the water in the hand, right? Over
it's sprinkled this way. Last year we had sprinkled this way. That I've been instructed is an insult.
So what is the exact definition of sprinkling?
Sprinkling, what we did last year, my lord, we took water.
Sprinkling.
That is what we did last year was, in my humble submission, the act of sprinkling. We sprinkle water on the stone, my lord. My instruction is that amounts to an insult. We'd rather not hold the yatra than insult that the structure.
So why do you sprinkle that way then last year?
There was no other way to do it, my lord.
You can do it with your hand. Yes.
So that will amount to pouring, my lord. So we were specifically restricted or prevented from putting it in our hand and pouring it.
By whom?
By the Durbar was there, my lord. Video cameras were there installed. Durbar was there to ensure compliance with SOP, etc. So pouring may be allowed, nominal amount, my lord, maybe 500
Yes,
ml also.
Mr. RP General. You're not audible.
Sorry, my lord. These are the religious practices, my lord. In religious practices, my lord, it is better left to the devotees, my lord. And the concern of Darbar is that it should not be the monument or it should not be defaced or.
Who brought up the sprinkling thing the last time?
My lord, because there was a lot, if Lordship kindly recalls.
Who brought up how does the sprinkling come about?
My lord, if
It is
Lordship,
not required. It is not required. my
if
lord.
Lordship recalls, if Lordship recalls,
It should not be part of the order also.
if Lordship recalls, there was a lot of resistance to us even, number one, entering the cave. Number two, even if entering, we are not supposed to do, we were not.
I think it came from your side only,
It
that
did.
only sprinkle.
It did.
Now you brought out that word sprinkle.
It did, my lord. That was my instruction last year. But then the community has taken
Mr.
offence.
General, that's the thing. Why did you bring that up in the first
My
place?
lord, that was my instruction that allow us to at least sprinkle and
Why sprinkle? If you knew it's against the practices, why do you?
My lord, unfortunately,
pray for the court that we allowed to sprinkle?
Unfortunately, last year, my lord, the petitioner society was not properly informed that sprinkling may amount to an insult. Now
They're conducting this yatra every
so the
time
question of
for 10, 12
my lord,
years. So
appreciate that the question of sprinkling or pouring never really came up.
it doesn't matter actually.
So I mean, to make the best of a bad situation, we requested that at least let us, if nothing else, at least let us sprinkle. So that was the context in which the whole issue of sprinkling came about. But now the community has taken
I remember it came from you.
It did, my lord, reflected in the 11th July order. It did come from me, my lord. That was because of the circumstances that existed last year, my lord. But now the community has taken umbrage at the fact that we have to sprinkle water on the deity, which amounts, according to the
Then
community.
we'll record. Yes, the Learned Advocate General with Mr. H. Abraham has produced before this court the status report with regard to the permission that with regard to the holding of the yatra. This court notes that the minutes of a meeting held pursuant to the order of this court dated 5th 8 2026 was held by the Deputy Commissioner. The same is taken on record. Annual form taken on record. Similarly, status report by Superintendent Police, wherein the assurance has been made with regard to security deployment and public order maintenance and compliance with the 2025 Standard Operating Procedure, has also been noted. This report is also taken on record. Next paragraph. Mr. S. Jindal, appearing for the petitioner, has submitted that the petitioners, in view of the positive, positive approach by all by the state government, as also by the Darbar and Headman Mohsen Ram, are what was the word? See, but approach are you are what's the word? Not gratitude. What's the word? Appreciate. Yes, appreciate the steps that have been taken by the authorities and also the all the authorities, including the Darbar. Stop. However, the Learned Council has pointed out that in the SOP of 2025, I think we will not record that. That will create another problem again. You bring up the NOC again, you'll come for the, then you'll come again for saying like sprinkling thing, then the NOC thing. You'll not Tom, no? Last part. Including the Darbar. However, a small prayer has been made that in the earlier orders of this court, it is recorded that sprinkling is allowed when they visit the cave. He prays that that the devotees, that the visitors to the cave who are part of the yatra may also be allowed to pour a small amount of water. Yes, as a mark of respect. Yes. Stop. Stop. Next paragraph. What anyone else anything to say, Mr. Chanreso?
Our objection will be recorded reflected in the order.
What objection?
That the village is not agreeing for yatra.
But then see what have you don't have instructions from your village.
But we have.
Then what did they say? They took part in the meeting.
Yes,
then
they instructed them to give a reply in writing. So the person has given a reply.
No, but then in the meeting, see what they say. You've seen this minutes of the meeting.
But we just received them.
Then you see the last. You see paragraph. Third last paragraph.
The last paragraph of the
yes. Then you give a letter. The third last paragraph of this SOP. We want to look at that.
Yes, yes. But PTO, my lord, starting from PTO.
Yes, let's read.
But the PTO was to share a copy of the letter, 6 August 2026, received from the headman of Mosenram village, wherein it was decided.
See the last two lines. Although the village do not agree yatra, but they would continue to treat all visitors. So that's it.
So, my lord, what they mean is they are not agree for yatra or religious activities, but all the visitors, irrespective of the backgrounds, the village authorities are ready.
Exactly.
All of them are. So they have an objection with the.
We note that. Yes. From the side of the state, anything to say? No. Yes.
So we are ready to provide security for maintenance law and order.
Submissions also been given by an Advocate General, and that as per the undertaking, as per the status report and the minutes, the state will ensure that the proceedings pass off peacefully. Stop. Next parameter, H.F. Chanreso, from the part of the respondents number
6
to 8, that is Darbash from Mr. Chanreso, submits that they are, though the village is still opposed to the conduct any religious activities inside the cave, and also have reservations about the yatra. However, they would continue to treat all visitors on equal footing with respect and dignity. Stop. The submission is noted. So, next paragraph. In view of the developments that have occurred after the order of this court dated 5/8/2026, for the sake of convenience, the minutes of the meeting firstly are reproduced herein below. Stop. Next paragraph, perusal of the minutes would show that the yatra can be conducted, and that all the visitors would be treated with respect and dignity by the Darbar Shinang of Mosenram. Further, next paragraph, the status report furnished by the Supreme Police East Khasi has also been perused and has been perused, which reflects that adequate security preparedness will be provided by the district police authorities as per the requirements which have been detailed in the status report. Stop. Next paragraph. On the other aspect of the matter with regard to the visitors or the members of the yatra visiting the cave, what should we put it? Visiting the cave.
My lord, it is surprised last year what happened. Pursuant to my lord's direction, yatra was conducted. Now the organizers of the yatra, what they have done after entering the gate, they completely took over the area and regulating the system, put up the flags and telling all the visitors remove your shoes and sandals, go inside, my lord. So this has really, my lord, touched the heart of the villagers, my lord. They become the manager, they become the owner there. So because of that, the villager decided that for the time being, we will not allow any religious activities, my lord.
Okay.
So the villagers are still apprehending. On 9 or so, if they come, my lord, therefore,
don't do
villagers cannot take the responsibility.
All people will have equal right to come there also.
No, no,
Yes, if they just
Even
visit,
as part of that yatra on that day, but they can come.
Naturally,
Yes.
naturally, but because the yatra was being conducted at that particular moment, the shoes had to be removed.
the whole day they took over.
The shoes had to be removed.
Whole day they took over. The manager, the organizer of yatra took over. Other visitors are
If the
absolutely
Darbar,
unable to
if the
come.
Darbar is feeling left out of things, then Darbar is more than welcome to.
Not left out of things. See, if the other visitors also,
My lord.
then you know,
They're not allowed.
it's not a place which is it's a place for everyone.
Yes.
My lord, my lord. So we will not restrict anyone's entry. I mean,
Yes,
that assurance can be given, my lord.
From, yes, it is also made clear that all visitors on that given day shall be given access. Yes, and as reservations have been expressed by the Darbar Mausanram that other visitors may not be allowed to enter the cave
The cave here. The cave.
on the given date. It's feeling very vague, the order. Yes, and that's also further as the sprinkling part, further the members of the yatra are also permitted to pour a small amount of water,
Well,
if so desired. Yes. Stop. Next paragraph. As ordered above. This is not, we don't need, we're not disposing of. This is matter after.
My lord, the main matter, Lord, should be fixed for final hearing. I humbly pray.
The other parts regarding the mediation, there was a bit of a mix-up.
My lord will consider all these aspects.
With regard to the mediation proceedings that could not be concluded, this court will take up the matter for further consideration the next date. Yes.
my lord has been very kind. On just one small aspect, my lord. Usually the yatra was for 2 days. This time, because of local issues in accommodation, etc., we are holding it for 1 day. Normally, the timing is till 5 p.m. If we are allowed to hold it till 6 p.m., my lord.
That you talk to the district authorities.
Very well.
You can't go. I can't go and sit there and see that.
Very well. Very well.
Item number 5.
Obliged.
Yes.
May it please your lordship. Miss case 207.
Where's
He's,
Dr. Mozika?
He's in currently in court. Room number 1, your lordship.
After some time?
After some time. I'm grateful.
And you're obliged.
There's no suppose come instructions, correct? They've received instructions, I hope. They've received. You file affidavit also or no? Okay.
6.
Then we can take up the mosquito.
6.
What is this?
6 is those
It's
SOP
other
matters.
Who the people of the state? Yes.
Yes, my lord. We'll take up with the first item of the daily list, my lord.
In those matters, Lordship, we're supposed to file a rejoinders. Now,
Why you not file rejoinders?
the state has filed eight affidavits across each department, Your Lordship.
Right.
We had already filed 7 rejoinders, Lordship, today. We will be filing
Today?
another, Lordship. So we'll be filing another for one department, Lordship, that is left out. So can you grant us a week's time, Lordship?
So we'll post it for hearing.
Post it for hearing, Lordship. In the meantime, we'll
Yes,
file it.
yes. Mr. M.L. Nongpur, this matter, this kind of matter, Donald Soyan, matter be listed together with the other SOP matters. Yes.
Lordships,
From daily
I have
list,
one
item
prayer in item.
Item number 1. 1, 2.
Okay.
115.
The list?
Daily list is from item 1 to 115.
My lord, now we have supplementary 5.
Supplementary item 5 because it's a fresh matter,
6, my
Lordship.
lord. 6.
It is. Now it's 6.
Yes, my lord.
Yes, 6. Then
1 to 155. 115.
yes, as this matter is connected to the other matters appearing in the daily list from item number 1 to
115.
115.
115. list together. Stop on the next page.
Item number 30, 31, 63 till 106 is for the, you have not received the affidavit for the health.
They're not filing specific affidavits. They're filing just it's filing a general affidavit to every department.
You have not received.
Then you get it
We'll
from
give them copies.
Lordships, I have one prayer, Lordship, in item 6 of the supplementary list. Lordship, there's one petitioner who wants to withdraw, Lordship, from the case.
Why?
Lordship, he doesn't want to pursue right now, Lordship.
But you compelled them to file a case?
No, Lordships. No, Lordships. Item 6 supplementary list, Lordship, there are 9 petitioners.
So to item 6(9), this is matter together with the other connected matters appearing in items number 1 to
115.
155.
Yes, sir, 115, my lord.
115 today. Stop. Mr. M. Nongpur, however, submitted that respondent petition number
8, Lordship.
Number 8.
Kitborlang Pertu, Lordship.
Number 8. Shri Kitborlang Pertu does not wish to pursue the matter. As it prays that he be struck off from the array of petitioners. Subsequently objected to the petition number 8. Registry to strike off respondent number 8 from the array of petitioners. This accordingly. Then in the we'll take up the other matters.
Number 1.
Number 7 we'll take it up in camera. Not now, later. Yes. Number 1, 115. No, number 1, 116. Stop.
116.
With the 1M, one pass order to 115 regarding the rejoinder. Right about, that's just listening. List lang, no? Yes. Yes. In these connected matters, Mr. M. Council petitioner submits that to the 8 affidavits filed by the petitioners, by the respondents,
Lordships,
covering different departments. 7 rejoinders have been filed.
Yes.
He prays that he may be allowed
to file the remaining.
When?
By next week, Lordship. 1 week time.
Next time to file the last rejoinder. Prays allowed. All this is matter for 2 weeks for hearing. Yes.
Lordship, as per the last order, the state is supposed to take some instructions with regard to the staff nurse and paramedics, Lordship.
Let it be. Let them sort it out, yes.
116. Yes, my lord. 116, my lord. There's these applications for implement. It is pending with the board, my lord. I have not received their signature, so I'll be filing in less than a week, maybe 2 days, my
Why
lord.
do you have so much trouble with procedure?
No. There's no procedure, my lord. It's gone for signature.
Twice they have withdrawn.
It's allowed, my lord.
No questions allowed. The court allows.
Yes, my lord.
It's not a rule that you allowed.
They're supposed to file it.
I'm supposed to file my.
After 2 weeks, yes. On the prayer of the what's the council respondent number?
2 and 3. 2 and 3.
117.
My lord, the arguing counsel is to appear via VC.
Who's our counsel?
Please, your lordship. I'm praying if your lordship would take up this matter at the end of the board, lordship.
What is it for today?
Milords, it's a contempt petition, Milords. In this, it was for release of the bank guarantees.
All right.
Because
there's a matter from the arbitrator.
Yes, your lordships. So, Milords,
no, what's happened to the see what happened to the other civil revision? The connected matter.
My lords, that's listed on 19th of August, your lordships.
Okay, let Dr. Mozika come. We'll take it up then. Yeah.
My lords, that matter was listed, my lords, on my lords last week, and the appeal is admitted, my lords. It's for arguments.
No, we'll take it up. We'll take your matter up when Dr. Mozika. He's not in court right now.
Yes, your lordships.
Yes.
118.
Yes, Mr. Marak.
She will be filing an affidavit in the course of the day.
Very good. For all the respondents?
Yes, sir.
Yes. Non-consular just submits the affidavit in the course of the day. It's sort of tweaks for rejoinder if any.
Yes, Lucy.
119.
This is affidavit by the respondents.
Yes, my lord. I just received instructions from Mr. BK saying that he's not able to appear virtually. He needs a little time, my lord, to file his affidavits. Mr. BK.
Last time nobody appeared.
I don't have.
On 19/6, 3 weeks time was given.
Lordships.
And 16/7, they said today. That means 16/7 nearly 3 weeks again. Interim orders are there.
Only to no cause of action, Lordship. Otherwise, it's really not helping the petitioners.
And today also no affidavit has been filed by the respondent number.
All the respondents.
All the
The
respondents.
respondent stop. MSOI Bank appearing for the response submits that due to.
Actually, by next date, at least some instructions should be on board, Lordship.
It'll be on board before the next date, my lord. That is the instructions.
It submits that the affidavit will be on board for the next date. According list after 2 weeks. Orders to continue.
Item 120 is the same, my lord. Item 120 is the same.
Oblige.
Order 21.
Please, Lordship, I pray for some more time, Lordship, to file rejoinder affidavit.
Yes, further 2 weeks time allowed for rejoinder.
Much obliged, Lordship.
Order 22.
My lord, here I require time, my lord. My instructions are not yet complete, my lord.
Is against MECL?
No, my lord, this is with regard to they are challenging the DPC, my lord.
You appearing for?
I'm appearing for respondent number 6.
Speak up. Yes, you're a lawyer.
I'm appearing for respondent number 6, Your Lordship.
What do you want?
I'm praying for more time to file affidavit.
You are the private respondent.
Yes, Your Lordship.
Yes. No objection?
No, Your Lordship.
Further 2 weeks time is period allowed for affidavits by the respondents number 1 to 5, represented by R. Colney, and 6 by SK Norum.
SKH Norum.
SKH Norum. Just hearing them to you. Where's yes, where's Dr. Mozika? As we take up that hearing matter.
Still on legs, Your Lordship.
Let me look behind. Okay.
My lord may hear me otherwise. My lord may hear me otherwise.
No, they don't. We don't need to hear you. You have to come with instructions because you found out from
That's
that.
right. Yes, Your Lordship.
What to do? Yes, you want to conclude the matter today, Miss Case. Let's stack up 5 minutes. So a lot of manipulation.
Yes, manipulation, we said it at the motion stage, but then I did not have concrete substance to place before this honorable
your
court.
manipulation allegation.
And the other side, they had instructions, but they had instructions through the person who had manipulated. That is why they also did not have the opportunity to place. And now with the RTI and the information that has come from the source itself, it clearly says that the documents, manufacturing documents and submitting them and taking a tender, ultimately it's a public money.
It's a criminal offence.
It's a criminal offence, exactly. It is a criminal offence. And in fact, they came up with a complaint that they had filed one FIR that I threatened them that don't participate in the tender. And you know, everything changed that time because I did not have instruction on that. And that was something, a complaint made that I did meet him, but that complaint had nothing to do with the tender itself, the tender process rather.
So just threaten him not to put his tender.
No, I said that because I knew it's a small place, and I knew that who does what amount of volume of work in that area, and I knew that.
Where's this place?
This is in Mizoram.
Oh, where in Mizoram?
Mizoram in what is it?
Where do you stay?
I stay at
Champai.
Tulfals.
Yes. You stay in Serichip. Oh.
So 1.5 crores of minimum transaction one has to have in a financial year. And I know that people, business people that who, suppliers who really do this volume of work.
Yes, I mean, you have instructions with you, I'm sure.
Your Lordship, I have Lordship.
Yes.
But then I'm not authorized to place the same Lordship.
Yeah, that's also correct.
Yes.
Lordship, if as per your Lordship convenience, if this matter may be taken up after exhaustion of the hearing list.
It's already exhausted.
What do you want hearing matters there? You're there in a hearing matter, which Dr. Mozika has to reply.
Lordship.
You know. You've incapacitated the court. You're hearing theory done. Huh? Court hearing is human hearing, doesn't it? Okay. Oh, yes, those batch matters were there. Those were taken up today. That is 1, 2. That is how many matters were there? 30 years. But that is I was wondering why there's no other hearing list. What to do? We'll go into recess. Yes. Then we take up the other matter on camera now. Are you ready? Yes. We'll come back. This is a matter we have to take in camera.
My lord.
It's a bit sensitive.
Item number 5, supplementary list.
Now, what instructions do you have, Dr. Mojika?
But the instruction is only to the extent, my lord, that the experience certificate that was submitted by them, we wrote to Navodaya Vidyalaya Samiti, my lord, they confirmed that. And after that,
You cancel the thing then.
that's one aspect, my lord. The second aspect is there's a window of 48 hours, my lord, in GEM portal. In GEM portal for any objections, my lord. Now the work has been awarded on 1st of June. Writ petition is filed after that, my lord. And the 48 hours window that was available to them, my lord, is over a long time ago, my lord.
So, you'll give to a person not deserving who has misled the authorities and who is a criminal offence, should be blacklisted immediately. Can you allow, will you allow a blacklisted contractor to continue?
Not blacklisted as of now, my lord.
No, it should
No,
be
but now it appears, my lord, from the RTI which they filed that
I mean, it's
the documents is the
overwhelming kind of.
but only difficulty, my lord, is the essential supplies, my lord. How, so some transitional arrangement has to be made, my lord. That's one.
I was the previous supplier. I will
Till continuing now.
No,
No,
my lord.
no,
From
not now.
1st of June, the private respondent is there, my lord.
We're stuck with the problem.
Now, how it happened, the department wrote to the Navodaya Vidyalaya, my lord. There also something he managed, it seems.
How will the system run? The system of the country is broken that way. Even if it's regard food for Jawans and people engage in this kind of, it should be heavily penalized.
Plus the quoted price has a difference of 32 lakh rupees, L1 and L2, my lord.
I'm ready to pay that also if required, but
No, not that.
someone,
Some punishment has to be given to him.
No, we will take them into account. If they can negotiate, my lord, if they can offer at the given price, my lord, if they can give a counter proposal, my lord,
and
there will be win-win for both the parties, my lord.
We can't allow this.
If they can give a proposal at the
no, I give an undertaking here only now.
L1 price.
Yes.
If that's recorded, my lord, I'll
We'll
take a clear cut instruction, my lord.
Recorded in this case.
Yes, 207.
That is very unfortunate.
Yes, my lord.
What kind of background check do you all do when you give this contract?
No background check. I found out.
I mean, the system threatened even the people who accept it also.
We write letter to PM, but he gave a certificate of 1.5 crore turnover with Navodaya Vidyalaya. We sent it for verification. They confirmed it. And an RTA is something different, my lord.
Yes. You take down. They don't think.
Additional.
The writ petition, the incident petition, had been filed challenging the settlement of challenging the supply order for fresh rations, supply order for supply of fresh rations to the Assam Rifles, to the respondents for the period 2026-27, which had been awarded to the respondent number 6. Stop. Where the bid document, where is that category for?
Well, page 51, lots will see. Experience required 144 lakhs.
51.
Page 51.
1 crore 44.
1 crore 44 lakh.
Page?
51 of the writ petition.
The bid document.
It's a screenshot from GEM portal.
51.
Page 51.
Yes.
Average turnover of last 3 years 144
Where is that? Yes.
on the right hand side. Average turnover for last 3 years.
So, no, one of the requirements to be eligible, to be an eligible tenderer, was that the average turnover of last 3 years should be rupees 144 lakhs with the government agency, with the government, with the government. Yes. Stop. The challenge it is submitted by the Learned Counsel is on the allegation that it's number 6, number 4.
6.
6 million. Page 7 of my counter affidavit, that certificate is there, my lord.
Number 6, have you say you have manipulated, right?
Yes.
Let's be some. That's point number 6. Had manipulated the documents showing the turnover.
Yes, my lord.
Stop.
This case में
And to stop. Shwaka Tashan on the council fully what I wrote. Shwakata. Shwakata. Huh? So it's noted that one of the requirements yes, yes. Stop next paragraph. Next point. Yes, MS Bureau Learned Counsel for the petitioner has submitted that the challenge is on the fact that the challenge is on the financial capacity / turnover, which he submits. The response number 6 does not qualify, and by RTI by an RTI application has come to learn that the response number 6 doesn't meet this criteria. Stop. Where's that?
Page 16 in the Miss Case 207.
Yes. Learned Counsel have drawn attention of this court to the Miss Case which has been filed, bringing on record this fact.
Page 20.
Wherein at annexure.
Page 20 is the reply. Annexure D.
Where annexure D, bracket page 20 thereof, it is shown that the response number 6 has only done works amounting to rupees 7,81,285 and not rupees 144 as projected. Stop.
My lord, one more point. Page 19, your lordship, this is the certificate given by, they have denied this certificate, my lord.
Yes?
Page 19 is the certificate which was given by the contractor, my lord.
Yes. Reference has also been made by the council to show the misrepresentation made by respondent number 6, wherein it is shown that the respondent number 6 had supplied materials to the value of 1.5 of 1 crore 50 lakhs. Stop. She therefore submits that the factum of manipulation being clearly demonstrated by the RTI reply, the supply order in favor of the respondent number 6 is liable to be cancelled. Next paragraph, Dr. N. Muzika in reply submitted that, was his submission?
But the window was for 48 hours, my lord.
Though the matter appears apparent on the face of the record, which the authorities have taken note of, and proper action will be undertaken. However, as the window for recall or for action in the GEM portal being available only for 48 hours and the same having been passed at this stage, immediate cancellation will not be feasible. Stop. Added to this, he further adds that the fact that the respondent number 6 has taken over the supply, which concerns the supply of rations necessary for the troops, any disruption caused will be to the detriment of the Assam Rifles personnel. Stop. This court, on hearing the council of parties and on examination of the materials available, notes that there has been gross illegalities and fabrication. The gross illegality and fabrication been committed by the respondent number 6, who was not represented. No, he had never appeared. Was notice completed on him.
Page 53.
Yes.
53 of the petition.
Yes. What to say? Though notice was served upon number 6 and Mr. Kibi Kharlindo had ended appearance on the last date. However, today he submits that no further instructions were received, nor was a vakalat issued given to him for filing. Stop. This submission is noted. That's paragraph. Coming back to the eligibility criteria and the performance certificates that have been furnished. Stop. Even this person who has signed it, no, some action taken by this KV person also. Whoever is Danu or Banu or whatever.
Manu Sharma.
Or whether this was manipulated by God knows. You have to go for forensics because they can just transplant the signature and do something else. This was received by the deputy commanding officer. This is below. This service issued by KV, ostensibly, right?
Yes, my lord. But KV is in RTI is denying that this certificate was ever issued by them, my lord.
Yes. Some, coming back to that, really, as coming back to the financial requirements, sorry. As it is noted that a contractor's performance certificate, which is appended to the business application, bears the signature of who's this person?
Manu Sharma, principal, my lord.
Bears a signature of a certain B. Sharma, who Manu, see, Manu was given here in the Manu here. Signatures the same thing.
Similar.
Bears the purported signature of the principal of the, it's called PM Shri School.
Yes, ma'am.
PM Shri School, Jawahar Navodaya Vidyalaya, village, page 20, village Thungsulchia, where's which of so and so, which certifies that the number 6 had supplied materials, supplied rations to the tune of rupees 1,450 lakhs, and also that performance as a contractor was good. Stop. The veracity, this court notes also that the veracity of the said performance certificate and whether it's issued by the competent authority is also under a cloud. Stop.
In fact, Assam Rifles checked. They wrote back, my lord, to PMC to confirm it. There's a letter from them, my lord, but again signed by same Manu Sharma.
That is fake.
No, my lord. Lordship has my affidavit, my lord.
That is, he said it's 1.15.
Amount is slightly different, my lord, but
what a twisted case, yes.
But my affidavit, my lord, page 6.
First affidavit. First affidavit.
Affidavit filed on 11 June, my lord.
Yes.
Commandant Israr Ahmad, deponent.
Yeah, this is. Which page?
Page 6, my lord. Page 7 is the certificate. Then we wrote to the school, my lord. Page 6 on 8th May to confirm the certificate.
He confirmed it.
Yes, ma'am. We received the reply that is at page 10, my lord. Again signed by same Manu Sharma. He manipulated there also, it seems.
Who manipulated?
Private respondent.
Who knows who manipulated?
Who was manipulated by whom? I think Manu Sharma himself supplying rations to the. You never know. This is a really sad state of affairs. No? So, however, it's also noted that in the affidavit filed by the respondents number
1 to 5.
1 to 5 at annexure 2 thereof, a certificate, a letter dated 12/5/2026 certifying the annual transaction. But does not come. This does come to.
Yes.
It comes to less.
Come to less.
Less.
It's come to 60 something.
So perhaps I do not know. At least he does not meet the criteria.
Yes, sir. Thought no. However, it's also noted. However, certify the transaction of the respondent 6 for the year 2024-25 to be 34,15,000, and for 25-26 20,80,000. So, the same also has cast, and the same also the same also has created has cast further doubts on the status of the entire process of verification. Stop. The RTI reply dated 24/6/2026 which this court accepts to be the correct portrayal of the which the court accepts to be correct information supplied by the principal of social school would show that the amount for 24-25, the amount of supply done by the respondent 6 2025 amounted only to rupees 7,81,285. So, next paragraph. In the face of these incongruities and apparent manipulation, which at this stage this court is unable to attribute to any particular respondent, which is at this stage what before that with manipulation and fabrication, apart from the questionable documents, which have been furnished with regard to the financial capability and performance, there is no doubt in the mind of the court that the respondent number 6 has contrived illegally to secure the supply order as L1, as the lowest bidder. So, next paragraph. As Dr. Musica, learned DRG, submitted that the supply, there can be no disruption in the supply. It is therefore provided that the supply of the R6, Donor 6, shall stand terminated when?
Not later than 15 days. Not later than 15 days.
Yes, we shall stand terminated immediately. Not later than 15 days from this order, and such respondent shall continue to supply rations till such termination. We withhold payments.
Yes, my lord. They'll give the 11th price, my lord.
Yes.
They'll offer 11th price, my lord.
That will come later. Yes. And the payment for the supply from June 1st shall be withheld. For the
If
time
not
being.
already made, my lord.
If not already released, pending further action, which necessarily will have to be taken by the respondent Assam Rifles in accordance with law. Stop. Next, with the impending termination of the R6 and the red petitioner being the only other tenderer qualified in the technical bid, on the offer being made by the on
the offer being made by the
offer
petitioner.
being made by the constitutional petitioner that the supply of the rations shall be made at the
L1 price.
L1 price subject to that proportionate deduction of this time.
Subject to L1 price for the period to be determined after termination of the R6 contract. This court accepts the settlement. This court finds the proposal feasible and orders accordingly. Any other observations? Next paragraph. This court notes its displeasure and it's really sad, you know, that system. This court notes the manner in which the manipulation occurred. Notes its displeasure and unhappiness at the manner the entire proceedings have been conducted, especially that has resulted in the manipulation of the authorities. It's one authority that therefore required to put in place a verification process that's more robust and will not affect the troops who are dependent on the regular supply of quality materials. Needless to add, next paragraph, the respondent authorities are also to take appropriate action and cause an inquiry into the
Conduct of R6.
Conduct of the respondent number 6, as well as any other Woolworth's principle.
Some people they wrote a letter, my lord. Again, the reply also is forged, my lord.
Reply is forged, no?
The reply also, it appears forged.
And also inquiry into the manner in which the documents have been supplied, which should include to obtain a statement from the principal of the so-and-so school itself. In the event that the illegalities, it is felt necessary, appropriate criminal proceedings also to be initiated against the concerned person. With above directions, the petition stands allowed and is accordingly disposed of.
I'm grateful, my lord.
We'll correct order.
Yes.
117.
Here the civil division matter was heard, my lord. On it is
it's listed on 19th August, my lords.
It is fixed for further hearing, so we can await. Where's the next date?
Can you await further orders?
Lordships, there's no difficulty. Lordships, the only issue is this, that I have to extend the bank guarantees. The contract, my lords, was concluded in 2022. These bank guarantees had to be released in 2023. And my lords, I am in a catch-22 because I have to extend these bank guarantees, my lords. I am incurring those expenses because they write to the bank saying that if these bank
when are they expiring?
It has already been extended.
Lordships,
already been extended the last date.
My lords, I extended it on, my lords, just 2 weeks back, my lords, till 21st of September 2020.
Then you wait, you just
before that, my lord.
Just after 2 weeks.
My lords, let them not write a letter to the bank asking for encashment, my lords.
Yes, no, they won't encash it. Yes.
Till 21st we will not do it.
Yes.
Yes.
As it is reported that what's the other matter? As is reported that the civil division application pending in connection with the same matters to be listed on 19th of August for hearing, post this matter on 21st. Till the next date, the respondent shall not take any action to encash the bank guarantees furnished by the petitioner. Yes.
Highly obliged.
Much obliged. Hearing?
Supplement 8.
Yes. Rakesh Chopra.
My lord, in fact, I had argued the entire matter earlier. I had submitted a written notes, my lord. Lords, you have the table format of written notes.
No, only two points. Now close seal covers been opened.
Seal covers been opened.
So that matter goes.
Yes, madam.
That after goes. Only thing is that what is it? That APAR. Now. Okay. See, now one thing is that he had made some objections on territorial jurisdiction also.
Yes, madam.
Are you still maintaining that?
Yes, madam.
Then number 2, it also made on.
In fact, why I am maintaining that, my lord, because there is another matter pending before the division bench, my lord, where they have challenged certain rules. I have taken the same plea before the division bench also, my lord.
Then?
Because only because he is posted here, my lord, and all these adverse entries or whatever initiating officers and reviewing officers entries were made when he was posted somewhere else, my lord.
No, another thing is, you say these the directions contained for APAR are only directory and mandatory.
That's my first submission, my lord.
Yes.
And I refer to a decision also earlier, my lord.
And then only for reporting officer, not reviewing officer.
Now, the third point, what I've raised, what they are doing, well, they are only challenging the entries made by the reviewing officer, my lord, on the ground that these are belated.
No, he didn't support it. He didn't submit his appraisal also.
He didn't submit his appraisal, my lord.
Appraisal within time also.
Because the first entries are in their favor, my lord, they want to sustain that, which are also belated. If the first entries are second entries are belated, my lord, first entries are also belated. So the entire thing has to go, my lord.
No, one he didn't submit self appraisal in one.
And the second year he didn't submit, my lord, self appraisal, and even for the first year, my lord.
Yes.
My lord, if you also kindly page 3, my lord, of my notes.
These are your notes.
Page 3 of my notes.
This one?
This one.
Yes.
The last row, my lord.
Yes.
Appraisal of APAR for 4922 to 31323 by a reporting officer on 10/8/23 is belated. Appraisal of APAR for 4922 to 31323 by reviewing officer is also belated. Appraisal, my lord, I've given the date.
Where are we reading from?
Page 3, my lord, towards the end, my lord. In the bold letters, appraisal of APR.
So the second column.
After the state of UP, my lord.
Yes, para 10, 11, 13, directory and administrative supervision.
Yes, after that I'm reading, my lord.
Appraisal for?
Appraisal of APAR for 4922 to 31323 by reporting officer on 10/8/23 is belated.
Yes.
Appraisal of APAR for 4922 to so and so by reviewing officer is also belated.
Yes.
So, my lord, if the timeline is so strict, my lord, they cannot just pick and choose, say that reviewing officers is because it is belated, it cannot be applied. It was not maintainable. But they forget to mention
he
that.
Also submitted that the reviewing officers' entries are beyond the scope of your APR, like whatever procedure.
My lord, that I'll point out, my lord.
Yes.
So first contention is that reviewing officers' entries are belated, my lord, by 26 days.
Yes.
Now, I've given the dates, my lord. Submission of self-appraisal not submitted, my lord.
Yes.
Reminder to petitioner on 8/8/23 to submit by 10/8/23. He doesn't submit, my lord. Then reporting officer.
10th August.
on 10th August, my lord, on the timeline given to him, he does that, my lord.
This is done within time.
Well, even this is belated, my lord. Now they don't challenge this because it is in their favor, my lord. So what I am trying to submit, my lord, if that timeline is so strict, my lord, then reporting officers' entries have to also to be ignored, my lord, and reviewing officers' entry also have to be ignored if the timeline is strictly to follow. They cannot pick and choose and say that reporting officers, though it is belated, no, these are because these are in their favor, so those are maintainable, but reporting officers' entries are not maintainable. That's the first submission, my lord. Then I've given the timeline, well, kindly see. Even appraisal by reporting officer on 10th August is against the stipulated period of 10th June. 10th June was the timeline, my lord.
Where is written that? Where is given your note?
Page 3, the last sentence.
Well, you just say, even, okay, oh, sorry, yes.
Even appraisal by reporting officer on 10th August is against the stipulated period of 30th June.
Okay.
If reviewing officer's appraisal is delayed, reporting officer's appraisal is also delayed and beyond the date after forfeiting their right of appraisal. If the submission is accepted, leads to a situation that there is no self-appraisal, reporting officer's appraisal is void, reviewing officer's appraisal is also void, the petitioner cannot ask for condoning the delay of reporting officer delay of 40 days because the grading of 7 is in their favor, and cannot ask for not condoning the delay by reviewing officer of 26 days because the grading is not in their favor. So they can't pick and choose, my lord. Either both have to go, my lord, or both have to remain, my lord.
What happens in the situation?
No apart, my lord. Come back to say.
What happens is no apart?
No, the situation is, my lords, there will be a no report certificate.
No, I understand. No apart. Yes, and what happens in consideration of promotion then?
But that apart will not be considered at all, my lords. It will be as if there was no apart, my lords.
Right.
It becomes, it will not be considered at all in a negative or a positive way in any way, my lords. In fact, it will go on to show the failure of the reporting and the reviewing officer. To
okay, no, that besides the point. Yeah.
Okay. The next point, my lord. The plea is taken, my lord, that a secret note procedure was not followed. The lordship kindly comes to page 324, my lord.
Of your?
Of the writ petition, my lord.
.324
of the writ petition.
Yes.
At page 325, my lord, para 3.
Yes.
It is further conveyed the remarks against the integrity columns of officers reported upon shall be made by reporting officer in one of the three options. This was placed yesterday, my lord. Now, this is for guidance of reporting officer, not for reviewing officer, my lord. It clearly says shall be made by the reporting officer in one of them.
Yes.
No, so this applies only to reporting officer.
The same submission.
No, my lord, he's applying this to reviewing officer, my lord. They are applying this to reviewing officer, my lord.
Okay. Yes, then.
No, my lord, they relied on page 318, my lord. That reason has to be given.
Provision 2.
Yes, my lord.
A provision.
Yes, my lord. A provision made in the PAR in the relevant section for remarks by the reviewing officer to indicate specifically the differences, if any, with the assessment made by the reporting officer and the reasons therefore.
Yeah.
Now, in my note, I have mentioned, my lord, the reviewing officer has said, I have highlighted, my lord, over-assessed by IO.
Yes.
And yes, the IO has been liberal in his assessment.
Yes. What is subject to satisfaction? What is over-assessment? Liberal assessment. Does it have to record that?
But some reason, my lord, it cannot be a very detailed reason in the PAR entries, my lord.
No, suppose you want to, like, what do you call it? interfere with the entry made by the reporting officer for whatever reason. Will it suffice that it's, oh, he's been liberal, and then like suppose that was 7 of agreeing to the 7 grading or 6 whatever grading you downturn it to a 5.
But my lord, under 226, to what depth the lordship will, whether the lordship will start giving marks to them, my lord, that's what they want, my lord.
Marks, but I'm just saying that, whether the reason will suffice. Because see, one thing, Dr. Modi, please understand that a picture has been created also, that this officer has been under, he's like, there are all our attempts to.
My lord, I don't want to say much, my lord, because that will be beyond, maybe amount of beyond decorum, my lord. But my lord, there are some officers, my lord, in every department. My lord.
Of course they are, but the thing is that whether that overt kind of action is taken against them, which is so anyway. Yes, man.
The refer to Delhi High Court decision, was that an issue before the Delhi High Court, whether he is of unimpeachable character or not, my lord? Some observations by Delhi High Court, that was a matter pertaining to why he was not allowed to go on lien on deputation to National Highways, my lord. That was the issue with Delhi High Court. Delhi High Court is some observation, and that those observations are read time and again, as if that is a character certificate given by Delhi High Court to the petitioner, my lord.
Yes.
Now, my lord, for the next year, my lord, petitioner did not submit the APAR for 1/4/23 to 31/3/24 in time. Petitioner submitted APAR on 24/6/24. The APAR was defective.
By?
Lordship has my note, my lord.
You should have submitted by what date? By March.
March was the date, my lord.
More cutoff is when?
Page 276, of the writ petition. 30th June is the cutoff date.
Okay, 30th June.
Page 276.
Then,
but this is a OM relied by the respondents also, submitted 7 days before the cutoff date.
Now, the APAR which he submitted was defective, my lord. A letter was issued to him, page 185, that he was required to submit interim APAR before the reporting officer retired on 31/1/24, and the period from 1/1/24 to 31/3/20 being shorter than 90 days will be treated as gap period, and to seek clarification from the petitioner. Petitioner submitted clarification that he was on leave for some time, and as per self-appraisal is not received, reporting officer has to fill up APAR. Self-appraisal APAR of 23 submitted by petitioner was defective and further submitted beyond the timeline.
Okay.
Now the next submission is made by them, my lord, that representation has been disposed of by the deputy secretary, who is a subordinate officer. Now the speaking order itself says, my lord, the competent authority has rejected the representation.
Okay, that we are not concerned.
So he is only conveying or communicating the order, my lord. Now next submission is that the representation refers to feedback received from environment, my lord. Their case is that nothing else can be taken into consideration while disposing of the representation. Now, while deciding the representation, the views of reporting and reviewing officer, if still in service, is to be taken. Now, reporting officer was Sri B.K. Singh. His comments were received on so and so and placed on file. Reviewing officer was DG BRO, who is retired by then. His comments were not available. Now, OM dated says decide on the basis of material placed before it. The OM says, my lord, material placed before it. So it doesn't say my friend was reading word only, my lord, which only word is not there in the office memorandum, my lord.
It's not there.
Only word is not there, my lord. It was tried to be read in a way as if only word exists in the office memorandum, my lord. Material placed before it. Now the material will he can take into account the information received from the environment, my lord. Now delay of 18 months, that is one of the major grounds taken by them, my lord, in disposal of the representation. Timeline of 30 days directly, that is the first submission, my lord.
Yes.
The petitioner came to this honorable court only after rejection of the representation. If he was so serious about 30 days timeline, on 31st day or 32nd day, he could have come before this honorable court for a direction to dispose of the representation. Accused to the delay and challenged the same only after it was negative. He submitted representation on 11/9/23 and waited till 22/5/25 and even beyond 9/10/25 for filing petition. At this stage, the speaking order cannot be disregarded only for the reason of alleged delay. Even if set aside on the ground of delay, remanding the matter would cause further delay. Timeline does not say that if representation not disposed of within 30 days and disposed of beyond 30 days, what will be the consequences of that? Now, my lord, lots will kindly see the situation, my lord. Reporting of
now shall can be read as may. It says shall, right?
Yes, my lord.
Then the timeline. So
no, my lord, I put question to myself, my lord. If your lordship says that this disposal of representation is not in accordance with law, it is the disposal of representation is set aside. What is the consequence of that, my lord?
Yes.
Will that amount to allowing the representation, my lord? In my humble submission, cannot be, my lord.
No.
It can at best be remanded back, my lord. Or your lordship will give some findings on the representation. This representation should have been disposed of in this manner, not in that manner. If 22.5, I think I'm clear on that, my lord.
No, you say that
appeal has been
submitted representation on 23. Now 18 months he disposed on 25. So like
there is
you
delay,
think that even if he waited, that's his fault. That he should have run to court.
My lord,
if the direction is mandatory.
My lord, if I give up that point also, my lord, but at this stage, what can be done? What representation has been disposed of?
You said 30 days, okay. He submitted on 9/11, right? 9/11/2023. So it should be disposed of by 10/12.
Yes.
2023. So you say that since he waited till.
No, my lord, I don't press that point, my lord.
Then?
But I am pressing the second point, my lord. What relief can be granted at this stage? Even if your lordship sets aside that, the speaking order, what disposal of representation they passed, will that amount to allowing, my lord? There is no legal fiction here that if representation is not disposed of within certain period, it will be deemed to have been sanctioned or deemed to have been allowed. That is a creature of statute, again, that legal fiction, my lord. There is no such provision in the rules anyway.
Okay.
So only alternative can at this stage be setting aside, but there is no purpose will be served by remanding it back also, my lord.
Now,
or simply setting.
Now you maintain that it's only directory, the 30 days.
Well, that is my submission, my lord.
Can we ascribe any like other motives or reasons to the non-disposal representation?
But my lord, I am only submitting the consequence, my lord. Even if the lordship sets it aside, my lord, today, only on the ground of delay, or gives a direction that don't consider it, forget about this, this 22.5, whatever you have done. So what is the legal consequence of that, my lord? My lord, against, if I give some example, my lord, some disciplinary orders, disciplinary authority has passed an order of dismissal of service of somebody, my lord. For example, my lord, he files an appeal to Director General of Assam Rifles, my lord. Timeline is that within 60 days he has to dispose of the appeal. He doesn't do that, my lord. Now, what can be the consequence of that, my lord?
We understand that, yes. Any next point?
Now, next point is malified to respond number 6. It was very vehemently argued earlier round of hearing, my lord. Yesterday, Mr. Gupta, I don't think he pressed this too much, my lord. And respond number 6 is retired, my lord. He was 4 levels above the petitioner, and there is no reason to be
vindictive.
For him to be vindictive. He is not even in service now, my lord. I am pressing the point of territorial jurisdiction very vehemently, my lord. They
reply on that.
Because my lord, I'll just point out one minor. In the Administrative Tribunals Act, my lord, it is mentioned clearly that where the petitioner is posted, he can approach the CAT of that jurisdiction, my lord. Article 226, the provision is 226(2), my lord, which does not talk about the residence of the petitioner, my lord, or his posting of the petitioner. There is a substantial difference between the Administrative Tribunal Act and 226, my lord.
Now you see the board division bench and matter still seized.
It is still seized.
Territorial.
I've raised that objection.
So the finding comes out with territorial jurisdiction that means they'll have a
There will be a direct bearing on this, my lord.
and what to do? When's the matter fixed?
Fixed up. Yesterday the matter was heard, my lord. 3rd September.
Well, my lords, I'll satisfy on that. On the territorial jurisdiction.
Yes.
May I, my lords?
You finished, Dr. Monica?
Yes, the territorial jurisdiction, in my notes, I've mentioned where he was posted at that point of time. When
he was posted in
Dimapur.
In Dimapur.
Dimapur, and before that he was in the Dimapur since from 23. And he came to Shillong only in January 25.
So when did he file in Delhi? That point is not taken up there.
Which one, Mala?
Delhi High Court.
No, Delhi High Court was because the headquarters, all headquarters are in Delhi, my lord. Even NHIDCL headquarters is in Delhi, BRO headquarters is in Delhi, my lord. And those orders were passed from Delhi, my lord, when he sought deputation to NHIDCL, which has declined in some way or the other.
That is why I approached
Delhi. I guess that he has gone to Delhi.
Okay.
Malords, I had pointed out one judgment of Surishta Devi, Malords, relying on a Supreme Court judgment. Malords, I'll not trouble your lordships in going through that judgment. Malords, I'll just say one line. The Honorable Supreme Court has said that in writ jurisdiction, what is of paramount importance is the situs of the cause of action. If from the analysis of the facts stated in the writ petition and the material annexed thereto, it comes to the fore that even a fraction of the cause of action has arisen in favor of the petitioner within the territorial jurisdiction of this court, the writ petition would be maintainable.
That is 226 only. Yes.
My lords, now exactly, my lords. Now, my lords, what I'm saying here is the impugned order is handed over to me when I'm within the territorial jurisdiction of this court. One. If the analogy of the respondents is to be accepted, but since I am in a transferable job, the cause of action would have arisen within the territorial jurisdiction of at least 3 to 4 high courts. But it is not for the respondents to dictate a employee who is serving at the post chosen by the respondents. But a respondent who is having a presence all over the country through the nominated consuls, will they be at inconvenience or will I be at inconvenience? But what is the logic of the situs of cause of action? The Supreme Court says it is not in dispute that this impugned order has been issued to me here. One, the effects of this impugned order are felt here within the territorial jurisdiction of this court. But there cannot be any analysis by virtue of which the respondents can at this stage, especially after, my lords, the first writ petition wherein this objection was not taken, even in that case, my lords, the cause of action arose within the jurisdiction of various courts. But, my lords, this impugned order was handed over to me within the territorial jurisdiction of this Honorable High Court. But this is merely a delaying tactic. But the respondents in writ jurisdiction, in my respectful submission, cannot force an aggrieved person to travel, my lords, to different places merely because they say the headquarter is there. Is it their case that they do not have an office in territorial jurisdiction of this court? So much. This is my respectful submission.
Or lighter when I'll say, but the council is from Delhi is more convenient for the council.
No, I respectfully, that is on a lighter vein. I'll not respond to that. But one of the most important things which has been argued is that the 30-day period is one directory. Two, there is no consequence. But once the legislature says the word shall, what has to be seen is whether it was.
What will be the consequences of suppose setting aside that order and representation?
Yes, I'll answer that straight away.
My lord, only one thing I missed out. I'll just I'll take one minute. My lord, we are not interpreting statute, my lord. We are interpreting office memorandum, my lord. You can kindly keep that in mind, my lord. We are not interpreting any statute Not even subordinate legislation.
Yes.
These are executive.
Yes. Yes, Manoj. And Manoj, that is why, Manoj, after yesterday's hearing, I have come with something, Manoj, to assist your lordships. Manoj, that 30 days timeline, once it is held to be mandatory by the use of the word shall, Manoj, I had referred to two judgments, Bachchan Devi, Manoj, and Delhi Air Tech, both Supreme Court judgments, Manoj, wherein the Supreme Court, relying on Kusum Ingots, Manoj, and everything has said that, Manoj. But what I am today arguing is what will be the consequence, and Manoj, as an officer of the court, it is my duty to answer that. It's a very valid question which has been raised. Much that denial of the disposal of representation within 30 days has to be looked into in the accumulation of the facts. What is that delay? Why was that delay? If these two questions are answered, the consequence has to follow from the Honorable Court in a writ jurisdiction. But then I say that with humility, my lords. In 226, the consequence has to follow from the High Court. But why I say so? 30 date is fixed for a certain reason. Your lordships, when I read that OM, it said that ACRs are not completed on time. That is why the reviewing and the reporting officer have been encasted with a public duty to ensure that it is fulfilled on time. To ensure that this is disposed of in time and the promotion does not suffer. What my writ petition says is it was calculatively disposed of on 22nd May because the respondents was aware that it is in this year that I will be becoming eligible for promotion. Therefore, they kept sitting on that representation, my lords. It is in 2026, my lords, that I become eligible for promotion. DPC is to be convened. All the documents are to be sent. My lords, therefore, the delay of 18.5 months. My lords, as your lordships rightly pointed out, my lords, the plea of the respondent is I should have been coming to the court on the 31st or the 32nd day. What's very much it, and I must say, Manoj, it is a very I'll not use any word much to the contrary. I'll just say, Manoj, this argument cannot be accepted for the very simple reason a party who is himself at fault cannot be blaming the other person, Manoj, for the error. They were under a statutory duty to dispose of that representation within 30 days, calculating disposing it off on 22nd May to ensure that I do not get promoted. My DPC is hampered. My name, Manoj, is not declared as fit. That has to be seen, Manoj. Now, Manoj, what I'm very quickly, Manoj, I'll just go through. Manoj, it has been said that my 23-24 APAR was not submitted within time. Your lordships may kindly have page 276 of the writ petition. Manoj, it is respondent's own document for 23-24. The deadline of 30th April was extended to 30th of June.
276.
276. Yes, Manoj. Has your lordships got 276 minutes?
Yes.
Manoj, may kindly see 28 May 2024 OM, second column. Submission of self-appraisal to the reporting officer, 30th April revised to 30th of June. Admitted case of respondents that I have submitted on 24th of June. Admitted case.
Defective.
So much that is their stand. Is there any document to show that it was defective? Once I have submitted my self-appraisal and they take a plea that it was defective, I have already shown that everything was done to victimize me. Everything was done to ensure that I do not get promoted. My self-appraisal is on record. The only question which I am putting is, they say I submitted it to X, it was to be submitted to Y.
Yes.
Those X and Y are sitting in the same office, table apart. Self-appraisal is to the officer, which in my respectful submission was to the right officer. They say defective, they do not come on
okay. Right.
But when the respondents argue that it was disposed of by a competent authority, let the respondents show from the record who is that competent authority. Mere use of the word competent authority will not satisfy when there is a specific allegation that it has not been decided by an officer of competent authority. Two affidavits filed, nowhere, my lords, reflected. But the respondents has said that I have not strenuously argued on the respondent number 6 vindicative nature. But the reason for that is, my lords, I did argue 1, 2, my written submission say so, and 3, my lords, this is only an argument to, my lords, recapitulate the points, nothing more. But as on today, the consequence of that 30-day denial has to fall in my favor for 2 reasons. 1, my lords, that disposal being not in the within the time frame is for a specific reason of denying me the promotion to ensure that it is done at the 11th hour, and I cannot, my lords, take my legal recourse, or my lords, be again hanging in a position where I can't reach anywhere. Two, my lords, the respondents for their own failure cannot take the benefit by saying that it has to be remanded back or it can be left in the lurch. That will be saying that will be like saying a writ court, my lords, in 226 is helpless and powerless to do the complete justice. But to show that, I'm handing over one judgment, my lords, and this is directly on the point your lordships on yesterday, my lords, had said that when I asked for ad hoc promotion, your lordships very candidly, my lords, said that we will not, my lords, complicate the matter. But I am only assisting. I just want to hand over one judgment to your lordships. But it is directly on the point. Directly on the point. But BM Rao, my lords. Lordships.
That's not even required, my lord. We are arguing the matter finally.
But that is absolutely required.
For a week's time or for 10 days time till the judgment is delivered, my lord.
Sir, kindly allow me, sir.
After hearing till the judgment is delivered, my lord, there cannot be an interim order, my lord. They cannot, should not ask.
My lord, this matter is being argued. I can show a judgment at any point of time. Sir, please. Sir, allow me.
Show the judgment. I'm just disputing the relief.
No, my lord, this relief can squarely be granted. My lords, may kindly have this judgment. My lords, the issue involved is in para 1. Your lordship sees in this group of so-and-so petitions pertaining to service jurisprudence by a common petitioner under 226, assailing the legality and authority of the initiation of departmental inquiries and for quashing so-and-so. My lords, point 3 at page 2, Roman 3. Resultant ramifications, but it is squarely my case. Resultant ramifications on the administrative mechanism as well as on the independence and equal rights of civil servants are sharply brought into focus mainly on the grounds of bias, unfairness, malafide, victimization and colorable exercise of power with a view to project favored person junior to petitioner, preventing him from the zone of consideration by imposing so-and-so, adopting highly discriminatory action and approaching with exonerating all the rest 16 officers and similarly situated. But what I'm pointing out, para 3, for a minute. The petitioner is common in all 4 petitions, raising and involving the common dispute relating to the denial of promotion in the higher cadre to the meritorious petitioner on the ground and in the guise of alleged irregularities, starting of disciplinary proceedings as well as the imposition of minor departmental penalty in one inquiry. But I'll not read the whole judgment. But may kindly have para 5. Kindly mark it. I am not reading it. Para 5 is important in this judgment, my lords. Thereafter, your lordships may kindly have page number 13, para number 30. But very interesting judgment and to the point, otherwise I would have not been wasting the time of the court. Page 13, para 30. How these kind of issues are to be dealt with, my lords. The right of the employer or the master to take action for the maintenance of discipline in the employment has to be also considered and protected, but at the same time, in exercise of such powers, administrative or in its departmental inquiries, the disciplinary authority cannot afford to be biased or unfair, unreasonable, or act in a manner leading straightaway to the presumption of victimization and colorable exercise of power. The prerogative of the master is not untrammeled or unqualified for the purpose of maintenance of discipline and imposition of departmental punishment, even upon proof of misconduct. Even the nature of misconduct is very important for the purpose of imposition of penalty, as at times it results into deprivation of the equal right of civil servant or the government employee. The circumstances and the peculiar facts referable to the case of the petitioner since the time of his qualifying for consideration for the promotion would speak loudly in support of the allegation of unreasonableness, discrimination and want of bona fide in initiation and resultant imposition of department penalty. Your lordships may kindly jump to page number 16, para 43. Page 16, para 43, I am reading from the 5th line. The Honorable Supreme Court in State Bank of India versus Samrendra, referring to the decision in State of Andhra Pradesh versus so-and-so, held and made the following pertinent observations. The imposition of appropriate punishment is within the discretion and judgment of the disciplinary authority, and same should not normally be interfered while exercising power under 226, as the power is one of judicial review, not an appellate prayer. The power of judicial review is made to ensure that individual receives fair treatment, and not to ensure that the authority, after according fair treatment, reaches on a matters which it is authorized or enjoined by law to decide for itself a conclusion which is correct in the eyes of law. Let me kindly see C. The High Court undoubtedly would interfere where the departmental authorities have held the proceedings in a manner inconsistent with the rules of natural justice, or in violation of statutory rules prescribing the mode of inquiry, or where the authorities have disabled themselves from reaching a fair decision by consideration of material extraneous to the evidence. Now, this is just an iota. The High Court further elaborates on this. May kindly have the next heading, amplitude and altitude of the judicial review. In the realm of judicial review, the court is also required to consider whether the impugned action or the order suffers from the vice of arbitrariness, unreasonableness, bias, malafide, discrimination, and also victimization when the impugned action or the order is the outcome of exercise of powers in such and like manner, even under service jurisprudence. It is therefore absolutely necessary on the part of the authority to avoid arbitrariness even in a field where the relevant provision does not lay down any quasi-judicial obligation. This proposition is extensively explored by the Honorable Supreme Court in so-and-so. It also stated in para 3 in the said decision that in India, certiorari would be available even against administrative bodies not having any quasi-judicial obligation if the rights of the individuals are affected without conforming to the principles even of fair play. Fair play is the heart and hub of the provisions of Articles 14, 16 and 311(2) insofar as the matters arise out of service jurisprudence. What's para 48? The requirement of fairness implies that even administrative authority must not act arbitrarily or capriciously and must come to a conclusion which is perverse or is such that no reasonable body of persons properly informed could arrive at such decision. The fairness is an integral part of the principle of natural justice as also that of reasonable opportunity contemplated in Article 311(2) of the Constitution. Obviously, therefore, when the administrative function is statutory, the court must read into the statute or the rules, including the principles of natural justice, the requirement of fairness, which means the minimum principle of natural justice. This is the proposition expounded in Namduri. Para 50, your lordships may kindly mark, very important. The doctrine of judicial review is a great weapon in the armory of administration of justice. Judicial review is an integral part of judicial and constitutional process and mechanism. So long as the fundamental rights as well as the statutory rights exist and are part of our law, power of judicial review has to be exercised with a view to see that guaranteed rights are not violated or contravened. Judicial creativity of apex court and high courts in India is well known and appreciated, and the courts have adopted a positive approach in interpreting statutory provisions, constitutional rights, and the principles of natural justice. Insofar as the contravention that the impugned action and the order of the respondent states suffers from the vice of discrimination and differentiation, it is required to be accepted in the light of the peculiar facts of the case highlighted herein above and the relevant proposition of law. I'll come to the most relevant part now, para 59, page 20. In the opinion of this court, there is a purpose and policy behind incorporating the provisions for ad hoc promotion. Even when the employee's fate is in the sealed cover, the appointing authority is empowered to review such cases, provided the officer concerned is not under suspension, not my case. And admittedly, the petitioner has not been suspended in any of the inquiries, and as a matter of fact, he has been exonerated in 2 inquiries by respondent number 1, and in 1 inquiry, we have found a fit case for exoneration as the imposition of the departmental penalty is illegal. But I'm reading the last 4 lines of this paragraph. Again, the promotion is being made to the post of secretary as on purely ad hoc basis, and ad hoc promotion will not confer any right for regular promotion. The promotion shall be until further orders. The ad hoc promotion shall be subject to the final outcome in the pending departmental inquiries. But that is what the High Court says for ad hoc promotion. Para 61, Manoj. Respondent number 1 state cannot be allowed to raise technicality, More so when the state itself appears to have a partisan view qua the petitioner, and when the petitioner has become victim of arbitrariness and unfair impugned order in the departmental inquiries past. The judicial conscience would command and demand that in such a situational reality, the officer of such high rank against whom there is no adverse record in the past, though he has been in service since 1980, directly as an executive engineer who came to be promoted as superintending engineer in the year 1990, and even this court as at the interlocutory stage found strong prima facie case for giving promotion to consider the case of the petitioner for the post of chief engineer, same as my case. And he has been working as chief engineer since then, cannot be allowed to suffer by a writ court, merely raising its hands in helplessness and stating that in accepting the technical aspect raised on behalf of respondent number 1 state, it would evidently and unambiguously run diametrically opposite to the underlined design and desiderentum of provisions of articles 14, 16, 21 and 311(2). It is incumbent upon the court to consider the peculiar facts and special circumstances obtainable in a given case, and to see that justice is done and full and complete justice is rendered, so that in cases of service victimization and exploitation and vendetta against officers whose past record has led them to the one after other promotion is not further made to suffer. On this point, there is a host of judicial pronouncements which we will be referred. Once they have further referred to the decisions, Manoj, I will not trouble your lordships with that. What I am arguing today is not the respondents' pleas. As far as secret note is concerned, it is only for the reviewing officer, reporting officer, not for the reviewing officer. Which rule says so? If the legislature is conscious that you cannot doubt the integrity without following the process of law of natural justice, the reporting officer has to follow that, reviewing officer does not have to. Which rule permits so? But the OM says integrity is to be assessed only by the reporting officer because he is directly observing his work. Reviewing officer is not doing so, so he cannot comment on that. But my APAR of 22-23, as far as reporting officer is concerned, is done by an officer who directly observed my work. But his grading is
already argued. This is a rejoinder. You already argued. I have placed my argument. Now again repeating the same thing.
Yes. So, okay. So my respectful submission is, in the first case of 24th November, I showed that the charge sheet was, it was quashed. It was not maintainable. Despite the quashing, the respondents victimized me by adopting the sealed cover on 10th of December by showing that that charge sheet still exists. 2. Despite me filing the application, the sealed cover could be opened only after the intervention of this honorable court. 3. I have shown from 2022 till today the only intent of the respondents is to somehow ensure I do not get the last promotion. Once, as on today, I will be promoted on 1st of September because the vacancy is arising this month, and 1st September I get promoted. But if I am not promoted ad hoc basis without any right, my junior gets promoted. DPC, ACC will take time. They will be subject to your lordship's order, subject to the outcome of the present writ petition. But my lords, once my junior is promoted, ultimately
September they submitted
in the court, they have still succeeded in their sinister plan.
Cause of action will arise on 1st September. We are arguing the matter.
Sir, just a second. Sir, just a second. There is a judicial finding of this court that they have a vendetta. Challenged in a division bench, withdrawn. That finding has attained. That finding is final. But that vendetta is proved. My prayer D in this writ petition has virtually been proved by their own conduct, even when the matter is sub judice before the court. I am only saying without any right, subject to the outcome, ad hoc promotion, even High Court says it will not give any right, that can be given. But I will again be forced for a separate writ petition. And they will, ultimately I receive that. But when, by the time I am retired, I will get my post-retirement benefits. I'm fighting since then, proven that the respondent number 6 does it on a date 26 days after forfeiture date and does it 1 day after the court of inquiry. March 25th September 2023, a court of inquiry is initiated, and thereafter on 26th they make that adverse remarks without basis, without reasons, over-assessed. That's the compliance with principles of natural justice. And when they say that the comments of the reporting and reviewing officer were taken and material on record would mean within that period. The period of APAR for which I am assessed, it cannot be for a subsequent period, my lords. by no figment of imagination it can be. Therefore, my lords, what I'm seeking is quashing of these observations, reinstitution of the reporting officer, that is the closest possible. But under Article 226, your lordships have the power that this assessment, which is done by an officer immediately superior to me and to meet the ends of justice, has to be upheld, my lords. Reviewing officer without any basis, making those remarks without any disciplinary proceedings. As far as 23-24 is concerned, it was a failure of a public duty by the reporting and reviewing officer. There has to be a they have already issued a no report certificate. There is nothing much left in that. The observations have to be cashed. But the only thing, ad hoc promotion and a time bound schedule of 15 days for review DPC and 15 days for ACC approval. I am on the last leg of my journey, serving since 94, no adverse record till date. No adverse order on my service till date. I have shown the apart from 2014 till 24, 10 years, I have 103% efficiency, disciplined officer, hardworking, dedicated, honest officer, sincere officer. But I can take your lordships through that again. And immediately
No need.
But I become, my lords, a habitual offender merely because I file a whistleblower complaint.
As we conclude now, otherwise.
Yeah, you can conclude now.
My lord, only one reply I'll give to, because the judgment is in place, my lord.
Do complete justice.
Lords, you kindly see, ad hoc promotion can only be given when disciplinary inquiry is pending or criminal case is pending, my lord. Here is a case where please, the rules that were cited yesterday, also, Lords has gone through the rules. Here is a situation where his adverse entries are against him, my lord. The ACR or APAR is against him.
No, the whole APAR is like, in what you got in what's the word to use? Not in a flux, also in a total disarray.
Yes.
The entire APAR is disarray. That's the thing. So what will be the, what do you call it? The, what is the word also? To assess what will happen in these situations. Isn't this array? He also didn't file on time. Now the date is extended. Now the reporting officer didn't do the assessment on time. But the other question that still is like in the mind.
I cannot be made to.
Is regard whether.
Well, here is a case petitioner has complicated the things by himself, my lord. Now trying to take sympathy from this honorable court by creating some kind of an impression, my lord.
Cases that come because of complications that arisen by the petitioner or by the it's by the track record service. So how do you untangle this?
That's the thing.
If that's only how to untangle it.
In my humble submission, the preliminary objection may be considered, my lord.
Territorial jurisdiction.
Was that?
I place the Delhi High Court Justice Swatantra Kumar judgment, my lord, very categorically. I didn't want to take your lordship again because I placed earlier, my lord. Delhi High Court decision, substantial cause of action must arise within the jurisdiction. Simply communication of some order will not give jurisdiction. It may give jurisdiction to CAT of that where he received, if he is posted somewhere, my lord, but not 226, my lord. There is a clear distinction between the jurisdiction of 226 and Administrative Tribunals Act, my lord.
May kindly have Surishta Devi. Page number, my lord.
I think you already placed that. I was just trying to rebut only that when disciplinary proceedings are pending, ad hoc promotion can be given, not for other things. Well,
okay, we'll see.
Balance
Gujarat High Court says when discrimination is proved, the service jurisprudence says it has to be done, my lords. I'm in the hands of my lords, I have nowhere to go.
Let him place one judgment also, my lord. Let him place one judgment also where ACR is adverse, my lord, and the court is given ad hoc promotion, my lord.
No, but Gujarat High Court says service jurisprudence once there is discrimination.
The general principles of law are very good. General principles of law are very good, my lord.
But it is not general. I'm so sorry.
Obliged.
Yes, you can argue over the phone with Dr. Mozika.
I don't know. This matter I want to let to the rest, my lord.
Yes, I'm so obliged for the hearing. I'm so obliged.
Okay.